Hello, everyone, and welcome back to another episode of the Lawyers in the Making podcast. I'm your host, as always, Nate Crespo, and today we have another exceptional guest. He's a graduate of the University of Florida College of Law and is currently a partner at Freeman, Mathis, and Gary. He's held recent positions as a partner at Goldberg Segala, as well as a partner at Pretzel and Stouffer. Finally, he is the co-host of the Podium and Panel podcast. It is a great honor to welcome Mr. Patrick Eckler to the show. Patrick, how are we doing today?
Great. Thank you very much for inviting me.
No problem. Now, Patrick, before we get started, can you tell the audience a little bit about yourself?
So I came to Chicago for the weather. First, as you laugh, but that's actually true because I grew up in Florida, and if you've been there, it's hot, and it's not always hot here, though it can be. I came here as an undergrad, and then went back to Florida when it was my turn to pay, and then came back after law school, not intending to practice. When I went to law school, I've now practiced, and eventually I'll get it right after 20 years. Do primarily professional liability and insurance coverage work, so professional liability defense. No, I'm not trying to commit the professional liability mistakes myself, trying to avoid those, but also help others when they get themselves in those situations. And then I do insurance coverage, makes up almost all of my practice between those two. I'm the co-chair of our firm's professional liability group, team, something like that. They changed the names, and that's what I do.
Well, let's start off. You said you started off in the University of Chicago, and you graduated with a Near Eastern Language and Civilization degree, which I've never seen ever in my life. I have to.
It's about to get stranger when I tell you what I specialized in.
So please tell me, because I'm so interested.
So, my area of focus was Egyptian language, ancient Egyptian language. And I used to be able to tell you what all those little birds were and whatnot. Near Eastern language. So when you think of West, when you think of the West, or you think of the Far East, it's always relative to where you're talking about it from. And so if your perspective, when you hear the term Near East, it means what we call in modern language, Middle East. They're the same area.
Oh.
So what is it near east of? Well, Greece.
Yeah.
Near to east. But if your focus is the West, and by the West we mean that those people and cultures west of the Nile River, or west of the Rhine River, the United States, Canada, France, England, and so forth.
Mm-hmm.
Then all of a sudden the Near East becomes middle of East, not near of East anymore. The Far East remains far and East, but so yes, that's what the Near East means. So it orients you to the perspective of the people that are naming it. Tells you as much about the people that are naming the thing as it does about the people that you're trying to describe.
Yeah, that's fascinating. I mean, I just had to ask because I was like Near Eastern. I was like, what? But it makes a lot more.
My father asked the same question. What am I going to do with that? He's a very practical fellow. He's an engineer. Very successful at what he does, and retired now. But it's like, excuse me, you're going to do what now? So there you go.
So from that point on, obviously you go to the University of Florida Law School. So
not immediately.
So not immediately. So describe what happened.
So I coached college basketball for 2 years after law school, or sorry, after being an undergrad, and I coached high school for one. Taught in high schools both while I did that, and then decided to go to get a law degree.
So what went into that decision? Why did you wake up one day and you're like, I want to go to law school?
You'd be surprised to learn how many lawyers coach basketball.
Wow.
And and back in 25 years ago, there were several that I knew. Craig Estrick, and who was the head coach at Georgetown at the time, is a lawyer, and there were a handful of others. And so what it did, you need a graduate degree of some kind. They don't really care what it is, whether it's in, physical education or law or physics or anything else. You have to have a graduate degree. And so I went to law school never intending to practice. I went to law school to go back and be a basketball coach. So I had a scouting service while I was in law school, and that's when my grades were so bad. I living in Gainesville. I am, I can get to pretty much anywhere I want, or nearly anywhere in the state, on a night's drive if I leave early enough. I could, if I left in the mid afternoon, I could be in Fort Lauderdale and get back in the early morning hours and see a game if I needed to get to Fort Lauderdale to see a game, or Miami even a little further. But Tallahassee's 2.5 or so hours. Jacksonville's an hour and a half. Tampa's a couple hours. Orlando's a couple hours. Those are very easy to get to, and I put a lot of miles on that car. Then when it came time, I arranged my schedule so I graduated early. So I graduated in December because hard to find a job as a lawyer or as a basketball coach in the middle of the summer.
Yep.
And I wanted to take the bar exam, be done with that in February, and then be on the job hunt after that. But life took a different idea, and I ended up coming to Chicago and practicing law. So
that is utterly fascinating. For me, I love it because I played basketball my whole entire life. My brother actually played college basketball.
Where did he play at?
He played at Assumption College in Worcester, Massachusetts. You know what that is?
I do.
Wow, that is I'll be honest with you. You're probably one of like 4 people that I've ever met who have said, "Yeah, I know what Assumption College is," because no one ever knows.
I've heard of it. I could say that.
That is amazing. But yeah, it was Division II, so I've been around basketball my whole entire life, and it's great to hear that. And I didn't even know that a lot of basketball coaches have law degrees.
I wouldn't say a lot. I would say a handful, more than you would think. And and at that time there were several that I knew, and it's like, well, let's just do this.
So you started as an associate attorney at Newman. I'm going to butcher this.
Newman Ray's in Shelmadine. Yes.
There we go. Thank you. How was that experience? What'd you do? Can you describe what you did there? What you were kind of in?
I got that job because I was the owner of the firm. Jim Newman was also a Gator. He had I couldn't find a job, so let me back up here. So I came here. I had taken the Florida bar. I come to Illinois, and my plan, because my last semester of law school, I was a CLI, or certified legal intern, what they're called in Florida. In Illinois, it's 7-11, whatever. And so the girl that I was dating, she was at a big law firm, and they have a very big pro bono program, and they got me an interview at the public defender's office here in Cook County. And I had done my last semester of law school as a CLI at the public defender's office in Alachua County, Gainesville. And this is what I was going to go do. So I get here, and 2 days later, I've got this interview, and the interview is going great, and I feel like I'm going to get the job. And then he asks me, "What's your bar status?" I said, "Well, I took the bar exam last month in Florida. I'm taking the bar exam in July in Illinois." He says, "We can't help you." So what do you mean? Rule says, and it still does say, if you do not take the Illinois bar at the first opportunity, you cannot be a 7-11. So there went that plan. So folks, read the rules. I did not. I learned, and so I couldn't find a job. I ended up working at Borders Books on Michigan Avenue because I couldn't find a job anywhere. And actually, a guy I worked for there is now a general counsel at a firm here, or at a business here in town. It's a very small world. But anyway, I ended up couldn't find a job, and I sent out this resume blind, not knowing it, and I get a call back, and I hired 2 days later. I take the Illinois bar. Fortunately, I pass it. I get licensed, and then they paid for me to take the Indiana bar. So I took 3 bars in a year. Fortunately, passed them all, and was on my way. But when I was at Newman Ray's, I did insurance coverage and some tort defense, but principally insurance coverage. And it's more or less what I do to this day is what I did then. Many of the same clients, they're now my clients as opposed to someone else's, and developed the business. and the Shelmadine in the name. She now is a colleague of mine. She came and joined us about 6 months ago. So she trained me how to be a lawyer when I was a baby lawyer many years ago, and now she and I work together. So it's a very, very small world. You never know where an alumni connection is going to be of meaning, and you never know the people that you know. Don't burn any bridges, people, if you can avoid it. Sometimes bridges have to be burned, sure, but don't. She was looking at, got the shaft at the place she was at. We needed somebody, and she is perfect, and it's great having her. So it's a very, very small world.
Let's go back a little bit. Let's talk about law school. Let's talk about the first year. I always say it's very traumatic for a lot of people. Was it traumatic for you?
I was worried about basketball. I was a very bad law student. I do not do what I did in law school. I mean, I did okay. My grade point average, I was probably in the top third of my class. I wasn't terrible, but I wasn't great. My focus was on, I would walk out of class, take calls from coaches to deal with my scouting service. I mean, I'd get up and walk out of class and take a phone call out in the breezeway. And that's what I did, because that's what I was focusing on. I whatever. I didn't do it typically. I didn't do it in days when my row was on call, but I let's just say I wasn't the most dedicated law student. I had other things on my mind. And I did enough. It was very challenging, I suppose, at the very beginning to learn this new law language. I struggled with that for a couple of weeks, but ultimately picked it up. But I had just spent 4 years reading ancient Egyptian. I mean, at least this isn't a language I allegedly know. So there wasn't too much they could throw at me that I hadn't seen or hadn't been intimidated by. I thought, and I'm not a big fan of legal education, and if you want to expound on that, I certainly can. But I found law school to be, I hated law school. I thought I think it's terrible. The way we quote train lawyers, and the sooner it ends, the better. But that's unlikely. There's too much money invested in it. I did not enjoy law school much at all. I did it because that's what the hoop of fire is. You have to jump through. But yeah, don't do what I did, people, in law school. I mean, just say that.
So as much as you didn't enjoy it, did you have any experience that was like, this was my favorite of law school? What was like the most memorable thing?
When I was a certified legal intern, my last semester, I spent every moment I could at the jail, or in the court, or at the office, or at the courthouse. I mean, I was at the jail at least 4, if not 5 times a week during the week. And the best part about going to the jail is leaving it. And so I built a good relationship with the corrections officers, and with the deputies, and the judges, and all but one of the prosecutors with whom we worked. The way it worked in the system we were at was we were assigned to one judge, and anyone who committed a misdemeanor in our county between A and had the last name ending in A to F was assigned to Judge Crenshaw. And our group of lawyers were the public defenders in that room, and there was 3 prosecutors or state's attorneys in that room, one for traffic, one for general, one for domestic. And we got along with 2 of them, and we're able to represent our client. I think effectively represent our clients, and sometimes took 2 cases to trial and tried them before I graduated law school. I got a directed verdict on one and a dismissal on another for a Brady violation. So had the opportunity to get on my feet and try a case. Won a motion for writ of prohibition against the judge after I graduated, because she got something wrong, and it got around the courthouse that there was a law student that had gotten into it with Judge Crenshaw. And it wasn't like she was adverse to the criminal defense or criminal defendants. She was the former elected public defender of the jurisdiction. And I said to her, Judge, you're just wrong. And she counsel. She did not like that very much, hearing that from a law student. My mentor, with whom I am still friends and stay in contact, and she's like, "What are you doing?" I said, "She's wrong." And sure enough, I draft the motion, and last thing I did as a CLI, as I go up to the court, to the chief judge, who is the judge who is the first level of review for these things. Mm-hmm. And I filed my motion, and I went upstairs, and his assistant wasn't there. And he comes out, and I handed it to him. I, Judge, here you go. And he looks at it, and he knew what he had heard of that this was coming. So you're the little pain in the ass. Sure enough, he granted my motion, but I was gone by then, and I used that as my writing sample, as my applications. This was not only a thing I had written, I thought pretty well, but had been successful in getting my guy. Now, it'd been successful in getting my guy acquitted because it was a breach of the statute of limitations, was the argument we were having. I can't remember the particulars of it, but it got my guy out. But it being representing criminal defendants, and particularly those who were indigent and need public defenders, he promptly got picked up on a felony charge and was in the clink for the next 10 years. So I did my job, but it didn't stop him from involving himself in other not alleged, but proved criminality. So be prepared to be disappointed be prepared for your clients to let you down if you do that kind of work. But many of the folks that we represented either didn't do it, or if they did, it wasn't anything like what had been alleged, and they were getting a raw deal, whatever it happened to be. And giving them the opportunity, most of the folks I represented were not bad people who may have done something stupid, but that was about the extent of it. Very little of what they had done was really, truly nature representing misdemeanors as opposed to felons. So, but that was the best part. Go be involved in a clinic, go get on your feet, go, do something. Don't spend your third year in these crazy advocacy classes where they try to indoctrinate you. Go do something useful. The third year of law school is a waste of time unless you make it otherwise.
Well, that's great advice right there. That was a great story as well. I thoroughly enjoyed that. But you mentioned something that I feel is very important for people out there, myself as well. Having a mentor. Can you kind of describe the importance of having mentorship in the field of law?
I've had many. So when you work as a CLI, it certainly was the case in Florida. I know it's the case in Illinois. You can represent people in a certain class of work, but it has to be under the supervision of a senior attorney. And so whenever I was in court, she always had to be, not too far away. Or one of the lawyers had to be not too far away. But Sherry was typically the one that I worked with. And she was the one, of course, standing next to me as I was getting into it with the judge. And it was going to be her that was going to get in real trouble if I went too much further. She was going to get it as bad as I got it, because she was allegedly supervising me. It's critical. And I mentioned earlier, Sherry, different Sherry that now works with me, who I worked for when I was a young lawyer. And then as I've moved to different firms, and worked with other people in professional organizations that I've been a member of, and certainly taken advantage of, that's wrong, not what I mean, but certainly tried to build relationships with people that are senior and have experience in these things, then try to be a mentor to younger people. Learning to be a lawyer is not, you don't learn that very much of that in law school. Most of that is much of it's innate and the rest of it is learned. There's a core of knowledge that I suppose you get, but it's critical to work with good people, learn from them, and have them take an interest in your development, because you can't do it otherwise. It certainly, as I say, it's not happening in law school.
So now I have to ask: Can you expunge on your hatred for law school? Well, I have to know now.
It's there's a conceit amongst lawyers, I think generally, but amongst law faculty in law schools in particular, that we're any different than plumbers. We're not. We have different tools. There's nothing that this whole idea that there's some esteemed thing that we're doing. No, we're just plumbers. And we try not to show our ass crack, but sometimes we show it even when we're not actually showing it. I'm guilty of that as much as anyone. And I think it's just a view that this is this noble intellectual pursuit when it's just not. We have special knowledge about arcane things that many of our colleagues wrote so that we would all have jobs, and made it obscure and difficult for other people to understand so they couldn't do it themselves. And they'll probably throw me out of the profession for comparing us to plumbers, but it isn't the first time I've done it. Because you know what, plumbing is a wonderful profession. If your toilet's backed up, if you don't have hot water, there's nothing more important in your life than the plumber. And if you can't fix it, you better find someone who can. And that's not materially different than if you've got a serious legal problem. We like to think of it as something more than that. It's just not. And so as a consequence, they do this Socratic method thing. And I'll be honest, I think it's a great way to learn. Try to get the student, and I do it with the people that I work with when I'm trying to, the young people, and try to ask them questions, trying to get them to think about the answer. Because if they come up with the answer themselves after a series of questions, they're more likely to remember the answer. But at the end of the day, what you need to do, how do they teach a plumber? Do they send them to a bunch of classes? No. They give them some basics, they give them some tools, and then they send them out in the field to go start fixing hot water heaters and unplugging toilets. Because the only way you're going to figure out how to do that is to start unplugging some toilets and fixing some water heaters. That's what you do. So the law school thing, it's like the law school industrial complex. They grift us for all kinds of money. They make us take this ridiculous test. And I guess the best encapsulation I can give you of how stupid law school is was from my first year contracts professor, Professor Davis, who was wonderful. And he said, about a couple of weeks before the law school, our exam, he stood up in front of the class and he says, now, in a couple of weeks, we're going to have a law school exam about contracts. Now, this test is not going to test what you learned in this class. This test is not going to test how good a lawyer you're going to be. It's not going to test how much you know about contracts. It's going to test how well you can do on a law school exam about contracts, which is a completely useless activity, but we're going to do it anyway because you want us to. And let me tell you why. Because years ago, we got rid of grades. We went all pass, fail. And then you know what the law firms did? They started ranking you guys by LSAT scores. And you guys really didn't like that. So you told us to start grading you again. And he had been there long enough, so I believe what he had to say on that somehow people thought pass, fail was great. And so lawyers and their inimitable HR skills said, well, look at LSAT scores, something that's even dumber than law school. They found something dumber than law school exams. They invented the LSAT. I mean, it's getting a little dumber, a little better because they're getting rid of the stupid logic games. Yeah. Don't tell me that tests anything that has to do with logical reasoning. I've seen enough bad logical reasoning coming from lawyers and judges to tell you that none of them understand logic. I have on my wall here logical fallacies. It's a poster of logical fallacies. You can't see it here, but it's up there. And you wouldn't believe the number of logical fallacies I hear in a given day. And they don't need, it's not formal logic, it's just basic logic. Arguments from the entire legal profession is built on arguments from authority. It's a logical fallacy. but we do it because that's how the system works, and that's not, so it's not a logical fallacy because it's internal to the system itself. So otherwise, the system doesn't work. I get that, but there's this, as I started by saying, there's a conceit about what we're really doing, and it's not justified. We should do much more apprenticing. We should, you can learn what you learned in law school, the things you needed to learn, and the topics on the basics in the basic areas in a year tops. You don't need to spend the latter 2 years in law school being indoctrinated. You'd be much better off. You'd be much better off going out and getting on your feet, and it would, you want to talk about access, problems with access to justice, and people having, there's an army of law students out there that under the supervision could provide a ton of good service, get trained in the process. We produce better lawyers and assist issues with access to justice. Instead, we have them locked away in law school, and then we make them spend God knows how much. As I understand, Barbary costs what, $6,000 or $7,000 now. I thought it was expensive when it was $2,500 or so when I took it, and now that turns out to be a bargain. And then we make them take a stupid test, and then we make them take another test, the multi-state professional responsibility exam. I don't understand it. I don't think anybody's being made a better lawyer by it. And then we continue the fallacy when we make people we have mandatory continuing legal education. Another complete farce. So I have big problems with legal education and how we train lawyers, and I have big problems with how we continue to educate lawyers. And we would all be better off if we did those things completely differently. And we'd be a lot better off in a whole number of dimensions.
I have heard, talking to law students and lawyers, people saying that the third year is very useless. So it seems like that is a very consensus view. But I think something you said, like more apprenticeship. I know in the last episode when I was talking to Carl Berman, he was saying how back very early in America that there were no formal legal degrees, that you would have to get an
Lincoln,
apprenticeship.
take Lincoln is the most well-known example.
And I thought that was fascinating because like I didn't know that, but it should be like that. It seems right that it should be like that.
Do we really think that the amount or the quality of lawyering has gotten better the more that it's been regulated? Is there any evidence to support that proposition? I'll read it if someone's got it, but I'm waiting for it. I've never seen it. I don't see less stealing occurring because I took a third year of law school about some advocacy class in third year. I don't think anyone gained anything from that. When I took I took at least one and perhaps a couple seminars in the third year. When I took seminars as an undergraduate in ancient Egyptian, that was to prepare you for being a professor, where you came in and your job was to give an hour and a half lecture. As you had a 10-week class, which was so I was on the court. We were on the quarter system, and the classes that I took were all cross-numbered between graduate and undergraduate. So I was like I was like the only undergrad, maybe one of two undergrads in a class of 8 students and 1 professor. And so the professor gave the first couple weeks of lectures, and then the remaining 8 weeks were given by the students. And our job was to present for an hour and a half. And we had to, so it's preparing you to be a professor, which is preparing for a lecture. And then learning from your colleagues and doing deep research into this. And I could go into the whole story of my particular presentation on the funerary complex of Amenhotep III. I could do that, but in any event, but that served a purpose that was not only training but pedagogical as well. It was training to be a professor, but also it had pedagogy and learning about this particular topic. There is nothing pedagogical, and there is nothing productive towards the practice of law, and nothing that tends towards the practice of law of a seminar in law school. No, it just isn't. If it is pedagogical, it's on an area that's so narrow, it's only good for someone that wants to be an academic. And as I've said, academic law, they write for each other. No one reads this stuff. No one uses this stuff. On occasion, the Supreme Court will cite to, a law review article, and they'll be they're writing for each other. It's ridiculous. It's an academic topic, and the problem is it's not an academic discipline. It's a professional school. We're making plumbers.
I love the plumbers analogy. I'll be completely honest. I personally enjoy it. I think others would enjoy it because it takes a little bit of pressure off of them, because it'd be like, oh, like I'm getting into this very honorable field, but it's like, you're just doing what any other person would do.
It's a profession. The fact we have to go to an advanced school, we have to take a fancy test, we call it a profession. Okay, that's great. We get to charge more. Okay, that's fine. I get that too. But when we're trying to train people how to do the job, there's plenty of space for people that want to be law professors and write about stuff. Go do that. But for the rest of us, they're going to go actually practice and do the nuts and bolts, which is the vast majority of lawyers that are going to be criminal defense lawyers, or they're going to be transactional, practitioners and drafting people's wills, or, what mergers and equity, whatever it happens to be. The vast majority of us are going to practice law. They're not going to be teaching law. They're going to be practicing law. And so teach them. And there's plenty. You want to be a law firm, great. You want to do research, great. There's a place for that. But don't call that Don't call that what is going on in law school. That's not what should be going on in law school.
So let's change gears a little bit. Let's go back to what you were doing. So after Newman Ray's and Shelmadine, you then went to
Redonio, Camelli, and Hogue.
There you go. Thank you.
And it was very similar. My practice has been very similar, and through the years, there's been some changes. I've done more coverage at different points and more defense work at different times. All the firms that I've been at, because I went from Redonio, Camelli, and Hogue, and then I went to Patton and Ryan, which is a firm that is the principal lawyer there is a guy named John Patton, who is a fantastic lawyer, who's built his practice around parachuting into big cases at the very last second. He does that all over the country and in Chicago, and he has taken some massive verdicts. But his position, his role is to reduce the size of those verdicts, to make them not so massive. And he's very good at his job. And then I was there for a very short period of time. Then I was at Pretzel and Stouffer. It's a very well-established, long-standing firm in Chicago. I was there for nearly 14 years. And then I went to Goldberg Segalla for a short period. And then at my current firm, which I hope is my last firm, and I'm here for a very long time, Freeman, Mathis, and Gary, which is based out of Atlanta, and is for lack of a better term, it's an insurance defense firm. We have 34 offices in 19 states. We're growing very quickly, and it's a very exciting place to be. We opened the Chicago office. My partner, Jonathan Schwartz, and I opened the office here in March of 2022. We're now 18 lawyers here in Chicago. We started with 4, and so we're growing, and it's very exciting.
So in terms of, so you started as a partner, but it was like the branch firm, so it's the Chicago branch of the larger Atlanta firm?
No, it's all one firm.
Okay.
I came in as a partner. I mean, you'll learn that partner is there's typically 2 levels of partnership. There's partners who are non-equity that are just salary, that have a name for marketing. And then you have equity partners who actually own a piece of the profits. And they're what are real partners. And in some firms, there's buy-in to become an equity partner. Some firms only have one level of partnership, but that's somewhat rare. Nowadays, most firms have 2 layers of partnership because, for a variety of reasons, it's mostly marketing and billing. You can bill the person called partner at a higher rate than a person called associate or counsel, and for marketing, it's a sign of you've made it. That they have, typically it takes 7 years for you to become partner at a place, and if you've gone through that gauntlet, you have shown that you have the requisite skills. It's a whole range of skills. It depends upon the type of practice, If it's a transactional firm, I imagine they have different benchmarks they want you to meet than if you're at a litigation practice like I've always been at. And you've made those benchmarks and they've made you partner. And if you've made a partner at a particular firm, then that tells you or tells other people, it's a signal that you can actually do the job. And that's and certain firms, when someone makes partner, you go, he made partner there, so what? But if you make partner at certain places, they actually know that means something.
That's fascinating. I literally had no idea. It's blown my mind a little bit. It's very intricate. The fact that it's more or less a marketing ploy.
Yes.
To
be very honest with you, yes, it's a marketing ploy.
That's
somebody say I'm cynical. That's just it's also it's a mark of achievement by a person if they make partner, because you have to do certain things. And it's different at different places. At very few places is it that you actually have business, but it's the idea that the partners believe that you can get business in the future, because ultimately that's what determines it. But at the end of the day, some people just are partners who never have a dime of business of their own, because someone's got to do the work well, and they're usually excellent lawyers who can do the work. And having a little gravel in your voice, a little gray in your hair, oftentimes means you can do the job, or at least you've done it for a long time. And you've got to have some folks around there that can do the job, because difficult matters come in, and you need people to actually do the work.
Is it marketing for like people coming to the firm and being like, I need your businesses? Well, you're doing insurance, so are your clients usually insurance companies?
Yes, typically, yeah. And so it's a certain confidence that this person can do the work. And then there's different rates based upon, typically there's rates based upon the level of experience the person has. And then there is it's an acknowledgement that, if you have someone that's coming to market to you who's an associate, it's like, well, why aren't you a partner? Why if you've been out for 3 years, you're going to hire someone that's been out 3 years to do my work because he's been out 3 years. It's very unlikely that a person of that experience is going to get much work. Now, that happens, sure. There have been young people who have been fabulously successful. They're prodigies. There's not many of those running around. I certainly wasn't one. It takes time to build confidence in others and to want to give you work, to show that you have the experience. And part of that's because they know that you didn't learn anything in law school. So they got to actually have you practiced. Have you done things? How many hot water heaters have you fixed? Have you fixed a hot water heater like mine? That's what they want to know. Yeah, I've fixed 100 hot water heaters like yours. I do that every day. Okay, maybe I'll hire you. But it's going to take many years before you're going to get to fix the 100th hot water heater. It's going to take a while.
I love the simplification of everything. It makes it easier to understand, but also it shows as well how overcomplicated the legal field can become at a lot of times.
We like that. We want to make it difficult. We want to make it what's the word, opaque, so people can't figure out. We'll make it seem mystical. It's fancy. No, it's not. It shouldn't be. Our job is to make things simpler for our clients. Our job is to explain. And if I'm explaining and the client isn't understanding, then I'm not explaining. I'm confusing. My job is to try to explain why and have reasons. And if I can't explain it in a way that makes sense to the client, in that it is both legally correct and understandable, then I need to find a new line of work. I always ask you, does this make sense? Not really. Okay, let me try it and use shorter words. Because I could explain it to a lawyer and use the vernacular of lawyers in shorthand and explain it in a sentence. But if I have to break it down for someone that doesn't have that understanding, I have to break it down. And I think it was Einstein that said, is if you can't explain something to someone, I don't know if it was a length of time he said it to, or if you can't explain it to someone so they understand it, then you don't understand it well enough. So you have to have a mastery of what you're doing so you can explain it to somebody that doesn't understand what you're talking about. We can talk to each other, great, but that doesn't mean that anyone else understands it. And that's ultimately what you have to do, is explain it to a real person. they call those people clients. And as one of my mentors is very fond of saying, it's very hard to be a lawyer if you do not have a client. So you have to go get a client, and that's how you become a lawyer. Because a lawyer without a client is not a lawyer.
So talking about kind of the Einstein kind of the explain it to a 5-year-old kind of thing. Can you kind of describe the skills that have helped you throughout your career and that you've kind of gained over time?
I will say that the most important skill that I learned was as a first year in college about reading things closely and carefully, and learning to read the words that are actually there. And when we did it, the professor that I had, who most influenced me on that is what he was in what's called the Committee on Social and the Committee on Social Thought at the University of Chicago, which is a interdisciplinary committee that awards terminal degrees. And I forget what his specialty was in Rousseau. But I took a class from a year-long sequence, two of the classes of which we were on quarters, so there was three segments of it. But two of the three classes I had him for was called Classics of Social and Political Thought. And the first book we read was The Republic, and I remember we also read Machiavelli, read The Prince, and I'll never forget when you get to book 8 of The Prince, or chapter 8, I can't remember if they're books or chapters. In any event, chapter 8, he describes when you read it closely, Machiavelli's actually worse than what you think he is. When you read it closely, he discusses a guy named Agathocles of Syracuse, who murdered all of his rivals. And again, and what Machiavelli says is, when you read closely, is that Agathocles, as awful as he was, had favor with God because he kept power. Machiavelli's worse than what you think, but you only get that when you read it very, very closely. And so that's what we do as lawyers. We read closely. We read statutes closely. We read cases closely. We compare them. In my profession, a lot of what I read is our contracts. They call them insurance policies. And we read them closely and carefully and often, and draft them, and then read them closely again, and then try to apply them to particular circumstances. But it's that skill of reading, and reading closely and carefully, and then listening, which I don't do very well, is really important, because when you're trying to develop your case, a lot of that is done at deposition, and everyone focuses on the questions that get asked and not enough on the answers that are given. And when they go for like a script, get a young lawyer, they have a script. I'm going to ask these questions. Why don't you listen to what the answers are? Those are far more interesting, oftentimes, than whatever questions you've got. Now, there may be certain topics you want to get, certain questions you want to ask. Sure, I get that. Listen to the answers. Listen to what the judge is saying when they're ruling on your motion. Listen to what the judge is saying on other motions, so you know when you file that same motion what the judge is likely to do when it's your turn, and what not to do. Don't do that if the judge yells at someone or denies something and does so unhappily. But listening and reading, two things that we were taught in kindergarten. Learn to do them well. Those are the two most important skills I think a lawyer has. And that listening applies to clients. And I forget one. Writing, of course. I think writing is just the flip side of the reading. Writing very clearly, writing concisely. They're called briefs for a reason. And my favorite commentary on writing is in from this little clip from it's on YouTube, from A River Runs Through It, and the little boy goes down to Tom Skerritt's character, and he writes this thing up, and Tom Skerritt marks it all up and sends it back to him and says half as long. He comes back, gives it to him again, and he marks it all up and hands it half as long. And then he comes back a third time and he hands it to him. He looks at it, goes, good. And he crumples it up and throws it in the trash. And so it's be concise with your words. Legal writing should be direct writing. It should not be flowery. It should not be, it has purpose. It generally is intended to be persuasive, at least in my practice. But when you're writing to a client, write clearly, concisely, directly, answering their questions, trying to help them solve their problem.
So a lot in what you just said. Obviously, reading closely, listening, writing, the three big skills. I love the callback to Machiavelli. I'm a very big Machiavelli fan. I really am, and he is very intricate in what
have you read the discourses?
The discourses on Livy?
Yes.
So admittedly, I've gotten halfway through it.
Okay,
but
which translation are you using?
Oh, it's in the other room. I have no.
You should. I would commend to you the University of Chicago versions.
Okay.
The Mansfield translation.
Harvey Mansfield, yeah,
Harvey Mansfield translation, and then Nathan Tarkov has a translation of discourses. I took his class when we read discourses. That's all we did all semester, all quarter, was read the discourses on Livy. And I took that with Nathan Tarkov, who was a colleague of Mansfield's. So in the original, or translated from the medieval Italian into English, and I would commend that version to you, or that edition to you.
Also, I was going to say,
especially in combination with Mansfield translation of The Prince, because they translate the words similarly, because they're unified in that way. So Fortuno, which is obviously a very important concept, virtue, these concepts are very important for Machiavelli, and you want to see them, how they play out in the two different the two different books.
Yeah, I wrote that down. I definitely will be getting them. I'm a philosophy major, so I'm not that I'd like to do anything with that major, or degree, I should say, because there really isn't much you can do unless you want to teach it, which I don't plan on doing. I don't think. Who knows? But as well, the writing concisely, the being able to listen. I'm very familiar with the sort of listening part. Actually, this past weekend, I had a mock trial competition for through UAlbany, where I go to school, and we went to Geneseo. We came in second place. My team was very good.
Congratulations!
Thank you. Shout out to my team. But anyway, one of the big goals of mine is on cross-examination. I didn't want to come so prepared with questions to the point where I kind of stuck with it the whole time. My goal for the whole semester is, as the witness is doing their direct examination, I kind of write notes, have a sort of kind of bulleted list of what I wanted to get out, and sort of do from there. And I did it both times. It was it was much easier, actually, I found, than having prepared questions, because it not only is it easier for myself, because I could kind of work off of what they're telling me in the answers, but it kind of shows the judge as well that I'm actually reflecting on what's being said on direct examination. So I felt that was a good analogy into what you said in terms of listening, in terms of depositions as well, that the answers of the people are much more important than the questions being asked.
Yeah. So what you do, when you get good at taking depositions, you get a list of topics you want to cover. And you don't care typically what order those get covered in. If the witness goes talking about this, let's talk about that. Let's run that string down. We'll come back to it later, but come back to other things later. But if that's where the witness goes, that's where you go. And just let them talk, because a lot of times they're going to talk themselves into a problem. Apropos of your comment about listening to what the witness has to say, my first jury trial here in Illinois, the plaintiff, to make a very long story short, the plaintiff had made a concession that he lied during the deposition, in the deposition. And the plaintiff's lawyer, who's a very nice fellow, he did not pull the pin on that grenade in direct examination. And I had prepared my examination of the plaintiff, anticipating that, all right, I may mention it, but that's not going to be the feature. Well, he didn't. So crumpled up the direct exam or the cross-examination and start over because, all right, well, if you're not going to talk about it, let's go. And he wouldn't admit what he had said in the deposition. So I end up getting to read the entirety of the impeachment, the entire exchange where he admits that he lied about where and when he got treatment and that the good book told him not to lie. And the part where my colleague who had taken the deposition said, yeah, that in the Illinois Code of Civil Procedure. He so I got to read all of that. And let's just say the jury wasn't very happy with the plaintiff when that was done. Because juries hate liars. They don't care if they're plaintiffs or defendants. They don't like liars.
Well, that's a good thing to know for the future if I ever get into any litigation. And that's very cool to hear about an in real life impeachment, because obviously they have it in mock trial. It's not as crazy, but an in real life one, I feel like, is that a rarity?
No, I had my last trial, it was about a year ago now. It was a little over a year ago. I think I impeached him 7 times. The judge didn't care. It seemed it was a bench trial. She didn't seem to be impressed by all the impeachment. But it was fun. As he would say something, I go, well, Mr. So-and-so, at the deposition, you were asked this question, you gave this answer, and just impeach. It's like, that's just the exact opposite of what you just said. It's like, yep. It's like, you're just a stinking liar. How many times do I have to show you're a liar? No, it happens. Several years ago, a colleague of mine was trying a legal malpractice case, and I was helping him out with the witnesses and whatnot, but the client would let us have more than one lawyer at the table. And so he impeached the plaintiff at least a half a dozen times during the course. This guy just kept lying. It was like, you cut that out. So when you have your examination, when you're at trial, you've got your questions because you now know what he's going to say because you've already taken his deposition. So you do have a list. And you've got, if he answers contrary to that, you've got the impeachment right there. And he's got a binder with his deposition. The judge has got the binder. You've got the binder. All right, open to whatever page, line number, and start reading. And out comes the impeachment because you know the answers. Goes on cross. You literally know the answer. This is not discovery anymore. This is, I know the answer. And I know the answer because I asked you and you told me the answer. So there shouldn't be a surprise. And if you decide to change your answer, and you're asking closed-ended questions anyway, so you're asking questions where the answer is only yes or no, hopefully yes. You just get them to agree with you 50 or 75 times, and you've had a good cross-examination. He says 75 words. Cross-examination is you testifying, not the witness. And so you go do the testifying. And if he disagrees, then all right, that's fine. Let's play this game. Play stupid games, win stupid prizes. Let's go impeach you. And that's what you do.
One of my favorite quotes as well, play stupid game, play stupid prizes. I love that one. And that was like one of the first things I ever learned in mock trial is on direct examination, the witness is the star of the show. On cross, it's all you. Get after him, do whatever you can to mess him up. What I have to ask though, is the impeachment in like actual court, is it a formal process or is
yes.
it?
Yes.
Okay.
It's a formal process. You ask them if, on this date, were you placed under oath and did you give testimony? And then it's at that time where you ask this question, did you give this answer? And you read it and they say yes. And then you may draw the objection. You tell them where to turn and what page so everyone can see, because you may draw an objection that's improper impeachment, that what you're asking about isn't actually impeaching of what they just testified to. And you may have an argument over that. Maybe you have a sidebar, depending. In a bench trial, you may just do it right there, but it depends if it's going to influence what the witness says. But you have the argument right there as to whether it's improper impeachment or not. And then you read it and hopefully it's impeaching and the jury is paying attention.
So let's switch gears a little bit. Let's talk about your podcast because I'm interested. Is it a hobby? It is a side, or do you like doing it?
We do like doing it. We want to make a nickel. It's very narrow in its focus. Dan Cotter and I, we started doing it, I think, in the January of 21. I had wanted to do one for a long time and couldn't really. It was worried about the technical aspects of it, and then realized this actually isn't that bad. And originally I wanted to do it with a plaintiff's lawyer, and couldn't find somebody. And then Dan, I knew Dan a little bit, and he agreed to do it. And so it focuses on oral arguments in the Illinois and Indiana courts of review, the Seventh Circuit, and the Supreme Court of the United States. Dan and I both have columns in the Chicago Daily Law Bulletin. Dan's column focuses on the Supreme Court a lot. I focus, my column is for the defense. It's a column that focuses on civil defense issues or issues of interest to civil defense lawyers. And then I've had a fair amount of discussion of free speech issues recently as well. But a lot of civil procedure type stuff is what I discuss. And then, so we both have columns there. And then we, as I said, we focus on oral arguments. We've done some arguments from other states that are kind of in our areas. We both have an insurance background. So it's heavy on civil and heavier on insurance. And so we try to do 3 arguments a week if the volume is there, in the areas where we go, and then we talk about those cases. Typically I'll talk about 2, Dan will talk about 1. Dan introduces the thing. We split up the labor, and then we do our predictions sure to go wrong. We predict how the cases are going to turn out, which is always a dangerous thing. Although our record is pretty good, I will say. We do a rule of the week. We talk about, oftentimes they come from other LinkedIn posters. Corey Webster is one from California. We take a lot from him. And then we have a good time with it. We both are pretty active on LinkedIn too. So there's that.
Yeah, I personally, I love doing, this is only, what is it? This is the 6th episode. I love doing podcasts. I really, really do. It's a very fulfilling thing for me. And like, I'm not the biggest fan of school. So this is like, it's just so perfect for me. And I love talking to people too. I'm very interested in a lot of things. So I just had to ask. So as well, in addition to, your partnership with Freeman, Mathis, and Gary, you're also a board member of the Illinois Association of Defense Trial Counsels.
I'm actually an officer now.
Oh, you're an officer. That's been updated.
I'm a secretary. I'm the secretary treasurer of the Illinois Defense Council, and I am a past president of the Professional Liability Defense Federation. I'm a member of a number of other organizations as well, but those are the 2 big ones, I would suppose.
Yeah, I also have Association of Defense Trial Attorneys.
Yes. That's I'm a member of the ADTA. I'm also a member of the Defense Trial Council of Indiana.
So what exactly do you do there? Can you describe kind of, because I don't know what they are and I'm interested.
So those are all professional bar associations, but with a focus on people that do civil defense work. So the Illinois Defense Council is Illinois licensed attorneys focusing on the full range of civil defense work. DTCI is similar, only for Indiana. They're both what are called SLDOs, that is state and local defense organizations affiliated with Defense Research Institute, of which I am also a member. I'm also a member of the task force on third-party litigation funding with the DRI. And then the ADTA is a national organization of lawyers to select type situation, whereas the IDC and the DTCI, you can be a member just by being in the state and doing that work. ADTA is a select group, and it's a sister organization of the DRI, with limitations on geography of where people are located. And the idea of that organization is referral amongst its members. And then the Professional Liability Defense Federation is a national organization of lawyers who concentrate their practice in professional liability defense work, so doctors, lawyers, accountants, so forth. And that's a really great organization that I was privileged to be the president of during the pandemic, which was interesting to lead a bar association in the middle of the pandemic. I recommend highly against it.
Building off of that, it kind of sounds like they're big giant networking sort of networks.
Sure, but it's also an opportunity to build your brand. It's an opportunity to write. It's an opportunity to speak. It's an it turns out that the practice of law is a social activity, and unlike plumbing. And so in that regard, it's great. It's great to be around people that do something similar, to interact with those folks, to share ideas. There's a whole range of advantages to being in bar associations. And if someone's a lawyer, they should be in a bar association.
This is sort of a double question, but can you talk about the importance of networking in the field of law, as well as the fact of the importance of building your brand? Because I heard you say that, and I'm really interested in what you have to say about that.
So networking is critical, because most of your referrals, or most of your business, is going to come from other lawyers who refer you business for any number of reasons. And people go into in-house, they come back out, they come back and be out-house like me. I like being an out-house lawyer. I can't imagine being an in-house lawyer. You're supposed to laugh at that. That's a joke, being an out-house lawyer. And it's trading of ideas, and building your reputation within the community is really critical. I've done that principally through my writing through LinkedIn. I've posted, I think, every day, every morning for 6 or 7 years. I've kept all of my posts. I have them in a single Word document that's like 1,100 pages, so I can go back and find them with the links, so I can find them. My first line of research are my old posts, because I kind of keep them in my brain, and then that's really built off of that. That led to my column in the Chicago Daily Law Bulletin. It's led to business opportunities. It's led to a whole range of things. I'm not on Facebook, Twitter, X, whatever they're calling it this week, Snapchat, Instagram, any of that other stuff. There's sometimes I get very frustrated with LinkedIn for a whole variety of reasons, but it's really been a great platform for me. But you still can't replace the personal interaction of being with people at an in-person CLE, learning about topics from people that are knowledgeable in the field, whether it's as a presenter, which I have done often, very often, or in the audience, being able to ask a question or just simply listen. And the practice of the law does not stand still. It changes constantly. And that's one of the things that I find so frustrating about law school education, is they teach us like, well, now you know things. And so many law students come out and it's like, well, I know this. No, you don't know anything, because it just changed last week. Smith versus Jones just came down, and it changed things. So no, what you learned was wrong. And if you don't stay on top of things, you have no hope. It's critical, just as it's critical for any professional to learn all the new things that have come out. Whether it's medicine with doctor, or with drugs, or new discoveries, no different. Or accountants with tax laws that change all the time, or what you name the profession. I'm sure plumbers have the same problem. The basics remain the same. In the case of doctors, save the guy. In the case of accountants, pay the taxes. In the case of plumbing, make the stuff work. But how you get there may change, and change radically. And so you have to remain up to date on these things. And if you don't, you got no shot. And it makes your life much easier if you already know the changes. You stay abreast of the changes that are happening. And that's not only in the case law, but also in the rules and other things.
I absolutely commend your honesty and your straightforwardness, because it's my you're my type of guy. I love that it's just straight to the point. You don't sugarcoat anything. If you don't
much sugarcoat in our profession.
Exactly. If you don't keep up, there's no hope. And I love, for 6-7 years, you're doing a LinkedIn post every single day. It brings me back to the sort of, history of the Peloponnesian War. Odysseus always says to keep a log, and, he did it himself, and that's how he recounts the war. And it's very
well, how much recounting and how much politicizing there is in Thucydides is a story for a different day. But yes, I'm glad to say I could say I read Thucydides in 3 different classes as an undergrad. But yes, there's Thucydides is great. We like to call it scientific history. It's not. It's just his opinion. He just hides it better than Herodotus.
But I feel it is analogous to what you're doing with the LinkedIn post because and obviously like
it's very flattering to be compared to Thucydides.
I know.
If people are reading my stuff 2,000 years from now, something's gone wrong. Something's gone very, very wrong. Or 2,500 years from now, something's gone very, very wrong.
I feel it's very important to yourself as well to have all that information because not only do you have your own body of work that you can present to people and have a sort of I do things kind of thing, but it also allows you I'm a believer. I'm a believer that you are what you eat, and what you consume every day is very important in terms of not just like food, but in the media and what kind of writing do you consume, what are you reading every day, because you emulate that in a sort of way. So if you're always writing every day, especially for you're seeing the rule changes, you're seeing the different court cases coming down, you're very cognizant of where things are and also where things are going. And I find that very, very fascinating from my perspective, because you're always keeping up with the times. And you're staying hip to the law, as they should.
Hip to the law. It's hard. Sometimes it's like drinking out of a fire hose. So there's things that get missed. You try to catch up. You try to catch them, but it's also part of that network is people will put me onto things and say, "Hey, did you see this?" I go, "No, I didn't. Thanks for forwarding it." So I find out about things I otherwise would have missed because people know that I follow these things or have an interest in them, and they'll point me in that direction or give me the information so I can stay on top of it. And it's been a good thing.
So now a little bit of a more personal question. Obviously, you're always writing on your LinkedIn, you're working as a partner, you're doing law all day. But what does an ideal Sunday morning or an ideal Friday night look for Patrick?
Well, Friday night and Sunday morning would be very different. Friday night, if we're in Chicago, then I'm hoping that we're maybe get some ribs at Twin Anchors and go listen to some blues at up on Halstead. It's a number of places. We can go to Kingston Mines in all likelihood, maybe even finish off the evening with some catfish. But that probably looks like it's Sunday morning is probably going to look like work. Assuming Saturday night didn't take too much out of me. Sunday morning is might look like a run, some laundry, and some work. And if it's the right time of year, there might be some English football on the television.
You're an English football fan.
I don't get to watch it nearly as much as I would like, but yes, I do enjoy some footy.
Who do you support? I have to ask.
We got engaged in Barcelona, so I support Barcelona. But when I
love that.
So I said Sunday morning. That's why I didn't mention La Liga, because typically their games are played later in the day. And God, they start games at like 10 o'clock at night local. It's like 3 o'clock in the afternoon. You're like, the Spanish are just wild. Those people are crazy. I get up too early in the morning to stay up that late sometimes. But I just enjoy the English game is obviously they've got so much money. They can buy teams that are quite remarkable. So it's a never ending soap opera over there.
Absolutely. I'm a very big Chelsea fan.
Okay.
Who have spent a lot of money, over $1 billion in the last 3 years.
Well, they got their show for it. Where are they at in the table right now? I'm serious. I don't know. I have not followed it nearly closely enough this year.
Unfortunately, we are in 10th. So
that's why I thought they were mid-table. Okay, very good.
It's very unfortunate. It's all right.
With all that money, it's shocking.
It hurts. It hurts me.
Yeah, I hear you. That's
you know what?
That's hard.
This 2 weekends ago, we drew to Man City 4-4.
My brother, 4-4, yeah, that was.
My brother is a huge Man City fan, so it was.
Had he ever heard of Man City before 15 years ago? I mean, come on. These people that are Man City fans, come on, give me a break. It's a fraud. The whole thing. Never mind the FFP. I don't care about the FFP. The thing is a fraud. It's like a made up team. It's ridiculous. They hadn't won a championship since what, 1968, prior to being bought by Abu Dhabi, and now they like win every week, and it's ridiculous. It's fake. It's ridiculous.
Patrick, thank you for saying that. I'll be complete. He's gonna be listening to this and hear that and be like, "Oh my goodness," and he'll let me know.
I mean, I want to hear the comeback to that. Tell me what the response is. Tell me what the response is, please. I have to hear this.
I'm not sure what it would be.
I'm a fan of a fake team. Great, congratulations. I'm a fan of the White Sox. They're terrible. I'm still a fan. I still wear that crap. They're terrible. I'm just going to wait out the owner. Eventually, he'll die, and I mean, I don't want it to be anytime soon, or he'll sell. But he's a terrible owner. But these guys, I mean, they're great owners. That's great. But who's a fan of that? I don't understand. I don't understand what you're a fan of. I don't understand. What are you being a fan of?
It's I'm on the right side over here. I don't support.
Well,
it.
we'll get to you in a second. We'll get to you in a second.
I'll stay quiet then.
A darker shade of blue is a problem. Yeah, down in London. Yes, but at least it's like a team that existed that someone had heard of
exactly
2 minutes ago.
Exactly.
It actually had done something.
So. Finally, Patrick, we're at the last segment, last question. What are your words of wisdom to those law students out there, the aspiring law students, even the current attorneys right now? What do you have to say to them?
I think that much of what I've already said, but mostly it's be diligent in your practice, in your development of your skills, of your knowledge, and never think that you actually have figured it out, because you haven't. It will change. Our profession is one that changes constantly, and it's essential that you stay apprised of those changes. And so, as a practice development issue, you need to be diligent in. Every day I have a reminder to check recent cases from Illinois, Indiana, the Seventh Circuit, and the Supreme Court of the United States, so that I listen to oral arguments in those jurisdictions, not only for the podcast. I was doing that anyway. The podcast is just another outlet of what I was already doing. And it's been the best thing that's happened for me. I turned that into a marketing thing, but it started as, I need to do this in order to know what's going on. And I may have taken it to an extreme, but you asked what I do Sunday morning. When I worked at Redonio's office, Redonio, every Saturday morning, he would put negligence or insurance into Lexis and pull all the cases from the week that had those terms in them and read them. That was his way of reviewing. Every Sunday is what Nunzio would do, and that's how he stayed apprised. I do it every day. He did it one day, and some days he probably didn't have very much. And some weeks he probably had a whole lot. It may have taken him through Monday morning to read through everything. But some system for you to stay on top of the developments in the law is critical.
Well, I couldn't agree more, Patrick. Thank you so much for coming on, and
thank you for having me.
And for everyone out there listening, thank you for tuning in, and I will see you in the next one.